Good morning. I'd like to welcome everyone and call to order this subcommittee on government operations. It is one of the key subcommittees of the House Oversight and Reform Committee. And the title of today's hearing is Mixed Signals, the Administration's Policy on Marijuana. And this is the third in a series of hearings that we've been conducting in the subcommittee to look at some of the changes in the law and also some of the practices that we're seeing across the country in regards to the use and enforcement of law relating to marijuana. The order of businesses will start with some opening statements, myself and other members that wish to be recognized. When we finish with that, well, we have two panelists this morning, and we have the delegate from the district, Ms. Norton, who we'll hear from first. And then we have a panel of 1, 2, 3. We have 4 witnesses that we'll hear from in the second panel. We gather today, and I'll start out by saying with an opening statement, in fulfilling an important responsibility of the Congress, and that's the investigative and oversight role of this committee. We are sent here by the people not only to legislate on some matters, but also conduct the most important investigative and oversight role in the House of Representatives. And this is a long-standing committee. I'm pleased to be the senior member, having served here longer than anyone else, I think, on the committee. But it does fulfill an important role in, again, keeping government accountable and responsible. As today's hearing relates to the District of Columbia, I know there have been some public pronouncements about what is the committee doing looking at the district's law. And let me just start out by saying, first of all, the District of Columbia is not a state. It's not a territory. It's not a possession. In fact, it is a federal district. It's provided for under the Constitution and a specific statute. And let me just say that the law that we're talking about will impact, and that the district has passed, will impact not only the people of the district, but the people of the United States. And we have millions and millions of people visiting us each year. It is a law that is in conflict with some federal laws, and I think we have an important responsibility to review its implications. Am I singling out the District of Columbia for examination of the impact of changes in marijuana laws? Absolutely not. We've held 2 previous hearings in which we specifically looked at the impact in Colorado, which has gone beyond the statute in the district. And we're looking at other states too. More than 20 states have authorized and changed the legal framework of marijuana for medical use. And so this is, again, directed to our responsibility under the Constitution and laws, and particularly unique responsibility of the Congress over the district and in response to its responsibility over the District of Columbia. So again, on March 4th, we did a hearing with the Colorado U.S. Attorney, and we had found out actually on that date, and I think that's the date that the D.C. Council voted to decriminalize the possession of marijuana. The impact is significant. More than 20% can we put that little slide up here? More than 20% of D.C. is federal land, and it is, in fact, unclear as to how the D.C. criminalization will affect marijuana possession and consumption on federal land like the mall. I'm colorblind, but they tell me that the green you see is there's a great deal of territory that it, in fact, is federal land. I asked the question of staff, what if I'm standing on the mall, which adjoins, I guess it's Independence Avenue, with 1 foot on each this side of the roadway there, what the impact of enforcement would be. No one could tell me. There are many questions that have been raised by the district's adoption of a bill that reduces the penalty for marijuana possession from a criminal offense currently punishable by jail time to a civil offense punishable by a $25 fine. And again, it is in conflict with some of the federal statutes. Currently, we have marijuana as a Schedule I narcotic. Currently, we have different levels of enforcement and penalty for its use on federal property, of which you can see we have a great deal in the District of Columbia. So that's one of the reasons we're here. Again, I've had some people, including our witness, question our authority. Let me just review the authority. Under the Constitution of the United States, you want to bring that up, Article 1, Section 8, it's very evident to exercise the exclusive legislation in all cases whatsoever over the district. Our authority in this regard stems from the Constitution. As you know, the district was created by an act of Congress in 1790, and subsequently we have a 1973 law. You want to put that up? Home Rule Act of 1973, and it says, the Congress of the United States reserves the right at any time, and this is one of those times, to exercise its constitutional authority as legislature for the district. So we do have very clear authority in that regard. And then we are here in the House Oversight Reform Committee that dates back to the early 1800s, because the Congress wanted not only the authorizers to conduct oversight and the appropriators, those who created agencies or the District of Columbia, but also who appropriated, they wanted them to conduct the oversight, but they wanted a third party, and we happen to be that third party, the House of Representatives Committee on Oversight Government Reform. And clearly the law's Rule 10, Clause 1 point out that this is our responsibility. So with that, we will fulfill our constitutional and statutory responsibility and conduct this hearing. I'm not here to debate the merits or demerits of the criminal law. We're here to examine its impact. We're here to examine the enforcement questions. We're here to examine a host of questions. This is not the last hearing. We started out with the Deputy Director of the White House Policy on Drugs, and he testified to a number of items in conflict with statements we've heard from the President, in fact, even from the President of the United States, about, again, the impact of the current marijuana that we see in the marketplace, its physical impact, its also its impact on the performance and even intelligence of individuals. Again, sat at this table and told us some reasons why we should not lessen penalties and why we should, again, look at what's being done around the United States much in conflict to some agencies of the administration who are now in turmoil trying to figure out how they comply with changes, and albeit the District of Columbia, Colorado, or some 20 states' laws that have been passed. In fact, with many local and federal law enforcement agencies, and I'd ask the staff have we got a list of the in the District of Columbia, we have this pretty extensive list of enforcement agencies in the district, starting with the United States Capitol Police, the United States Secret Service, Supreme Court Police, the United States Park Police, even the Smithsonian have police. We have a whole host here of agencies that are charged with enforcing the law within the District of Columbia, and also have different sets of penalties that they must enforce that may be in conflict with the law that has been proposed by the district, for the district. So again, we have issues that relate not only to the district, but to law enforcement with other multiple agencies within the District of Columbia, and that have a legitimate law enforcement role in the district. So again, we are here to look at some of these issues, to explore the implications of this new law's impact on the district, millions of people who will visit here, and we hope to do so in a responsible manner. Whether or not we will make any further recommendation, I'm not going to prejudge. We haven't heard all the testimony. I invited the district to also send a representative from the district council, and I think they chose not to do that. I'm disappointed that they are not sending someone who actually adopted the policy. But we do want to provide an opportunity for the representative of the district, Ms. Norton, to testify and have her position stated on the record, as we'll do in just a minute. Are there further members that would seek recognition? Mr. Cohen.
Thank you, Mr. Chair. I just want to thank you for holding this hearing and for having the hearings you've previously had. I think that the statements in the previous hearings of the drug czar's representatives and the DEA deputy director that came here spoke for themselves, and they speak for the need for the President to replace those people and to have people in positions that reflect the values of America in 2014, the values that President Obama has espoused, and the values the people have espoused at voting in states throughout this country, where 21 states have medical marijuana and 2 have recreational marijuana. In this particular case, one of the things that I've really liked about the states adopting this is Louis Brandeis, my favorite Supreme Court justice, said that states are the laboratories of democracy, and that's the wonderful thing. Then there were 48. The states could try things and the others could learn and see what's good and what's bad. D.C., while not a state, is a separate jurisdiction and can be a laboratory of democracy, just as Brandeis envisioned. And no better laboratory of democracy than right here where the members of the House of Representatives are situated, to where they can see and be around and experience in their homes, in their home area, second home area, how this law affects the populace. It has a disparate impact upon African Americans, 8-to-1 in arrests, and it has a big effect on the D.C. budget and incarcerations and police time that takes away from other priorities that could be people spending on human issues that need to be addressed. I'm sure Delegate Norton, who does such a wonderful job representing the district, will bring these issues up, but I am a strong supporter of D.C.'s having the autonomy to address the issues as they did by a 10-to-1 vote, and appreciate the opportunity to discuss these issues in this forum. Thank you, Mr. Mica.
Well, thank you, and I should have asked for unanimous consent, since you're not on this specific committee or subcommittee, to participate, and without objection, we have granted you the ability to participate. At this time, I also want to ask unanimous consent that our colleague from Louisiana, Dr. Fleming, be allowed to also participate in the hearing and without objection, so ordered. So let me recognize further members of the subcommittee first. Mr. Massey, did you want to be heard? Okay. Mr. Jordan? Okay. Then we'll go to Dr. Fleming. Welcome, and you're recognized.
Excuse me. Well, I want to thank you, Mr. Chairman, today for allowing me to sit in on this and other members of this committee. I'd like to speak for a moment, not so much specifically about the law and the advisability of relaxing laws on marijuana, but just to speak as a physician and as a father, a family physician who's been an alcohol and drug medical director twice, someone who wrote a book about preventing addiction in children back in 2007, and what the impact of marijuana is today in America and also changing attitudes. You know, it was back about 20 years ago, I believe, that there was identified some theoretical value of the use of marijuana medicinally in the case of dying cancer patients, that it gave them some comfort. And of course, no one has any problem with attending to the needs of a dying patient, someone with a terminal illness. Somehow this has morphed, though, into claims that marijuana actually cures cancer, that it's necessary to treat nausea, and many other claims that have been completely disputed by the medical community. There's nothing that marijuana treats today that can't be provided by other medications that are much safer. Now let's talk about the safety of marijuana. Marijuana is an addicting substance. Again, there's a myth out there that it's not. The most common diagnosis for young people admitted to rehab centers today is for marijuana addiction. Make no mistake about it. Now, there's also the discussion about marijuana as a gateway drug. And I'll tell you what drug addicts tell me, and that is that every addicting substance is a gateway drug to another addicting substance. Marijuana is not excluded. I would even include alcohol and perhaps tobacco in that category. So any exposure of an addicting substance oftentimes leads to worse addictions. What else do we know, science? We have learned, we have many studies now that confirm this, that the human brain does not fully mature until almost age 30. Yet, the average age of a child who has first exposure to alcohol, tobacco, or marijuana is around 11. And what we've learned is that these drugs, these addicting substances, actually modify the brain and its chemical pathways, the biochemical pathways, and the neurotransmitters, and sets the stage for addiction later in life. In fact, children who are exposed to such addicting substances prior to age 15 have a 5 times greater risk of future addiction than those who are not. So there's no question that the rate of addiction goes up with exposure in young people. 2 very recent studies have come out, have important impact. They came out just this month. One is being published in Neuroscience, where they did MRI scans of people who use marijuana only once or twice a week. And what they found was profound changes in 2 aspects of the brain, areas that confirm what we've believed all along, and that is something called amotivational syndrome that occurs in regular marijuana users. Also, the incidence of psychiatric diseases, particularly schizophrenia, is higher among chronic users. Heart disease, we're seeing a spike in heart disease among marijuana users as well. Now, there's also a libertarian argument on this, that why should government stand in the way of people utilizing a substance if they wish to do so? And theoretically, that makes plenty of sense, but the problem is you never hear libertarians make the claim that when I'm unable to get or keep a job and I can no longer support my family, that I will also tell the government not to take care of us through our growing entitlement system. So again, I would always challenge those who argue on a libertarian basis, you can't have it both ways. If you can do whatever you want with your body, that is, ride a motorcycle without a helmet or whatever, don't expect society and taxpayers to take care of you when you're suffering from those circumstances. So again, I want to be sure that we have the facts in front of us. We're getting reports now in states like Colorado where marijuana has recently been made legal, where children in the 4th grade are now dealing the drug. It's finding its way into food, and now we have a spike in poisonings in emergency rooms where children have actually ingested marijuana and become quite ill. So these are all important things I want to be sure we have out on the table, Mr. Chairman. And once again, I thank you for the opportunity to join everyone today, and I yield back.
Well, thank you. Do other members wish to make opening statements? Yes, Mr. Massey?
With all due respect, I just want to clarify that libertarian position is not to have the government take care of you if bad luck befalls you or you make poor decisions.
Would the gentleman yield on that?
Absolutely.
I would agree that should be the libertarian, but I interact with people every day on this subject because of my stance on it, and I can tell you, and I would actually say that there's kind of a faux libertarian group out there who make the claim on the basis you say, but they never come with the second part. So I agree with you. If you were to take a libertarian stance on this, if I were to choose myself, for instance, to ride a motorcycle without a helmet or to use marijuana and tell the government to stay out of my life, then like you, we should also demand that government not provide us benefits to the charge of taxpayers to take care of us when that happens. So we agree philosophically. I'm just saying there are many who make the claim under the umbrella of libertarianism, and it's not libertarianism at all, as you well state.
Yeah, I agree. Thank you.
Mr. Chair,
Yes.
can I ask a question of my colleagues?
Well, Mr. Massey had time. Did you wish to yield to Mr. Cohen?
I'll yield time.
Thank you. I just wonder with your argument, Doctor, should we outlaw alcohol so we don't have to pay for the alcoholics who can't get a job and who we have to pay for rehabilitation and for DWIs and for assaults and murders when they're drunk and all those type things? Should we get rid of alcohol?
Would the gentleman yield? I'd be
Yes,
happy
thank
to
you.
respond. Great question. You know, alcohol has been an accepted part of our culture and even our religious practices for centuries. We did try, even with an amendment to the Constitution, to prohibit the use of it, and it just was not culturally accepted. It is very problematic, but I would also say that on a medical basis, that moderate amounts of ingestion of alcohol actually have positive health effects. That is, again, not to diminish what it can do. There's no question that it, too, can damage the brain, the liver, and many other organs. But that it's not realistic, given the cultural acceptance of alcohol, to prohibit it. The same is true of tobacco. We used it for 400 years without realizing that it was a problem. And in fact, as recently as the 1950s, doctors actually recommended smoking, at least on commercials, for health. And we found out, of course, in 1969 when the Surgeon General came out and said that it causes lung cancer and many other problems. But we've done a lot of things to mitigate the use of it and the damage of it. But marijuana is different. The public has never accepted marijuana as a part of our culture. I know that that seems to be changing, but I think we can turn it back in time to prevent that from inculcating itself into our culture and damaging more young people and ultimately causing severe health care problems later in life.
I thank.
I'll yield back my time so as not to derail this committee hearing.
I thank the gentleman, and as you can see, there's a lot of debate, not only among various groups, but among members of Congress from both sides of the aisle and within the parties themselves. And what's happening is raising many questions across the United States, both the change in the law in the district, but it does have implications. I'm going to yield to Ms. Norton in just a second. I do want to provide at this point in the proceedings the penalties for marijuana possession, starting with Federal Law 21 U.S.C. Code Section 844, which has simple possession that it can provide for 1 year of imprisonment or a fine of not less than $1,000. That's the federal law. The new D.C. law is $25 penalty, a civil penalty. Federal parkland penalties, in fact, are a fine or a jail term up to 6 months. There are 26 agencies that are responsible for law enforcement. Now, I have this joint here, and this is, okay, don't get too excited out there, some of you. This is not a real one, it's a mock one. But I'm told by staff that this joint, Ms. Norton, that the penalty is, let's see, you have up to 1 ounce or less. 1 ounce is 28 grams, is that correct? And each joint has about 1 gram, so over 20 joints you could be in possession of in the District of Columbia. Here's the list of penalties, which I'm submitting to the record. I can't submit and this, as I said, is a faux joint, but for the record, I will submit this list.
Did you roll that?
No, I had staff do it. They have more experience. But all kidding aside, there are very serious implications, Ms. Norton, to what the district, step the district has taken. We want an open, honest airing of what's going to happen, how this is going to be enforced, and the implications, and that's why we brought in federal and district and other officials to discuss this in an open and honest manner. So with that, I welcome our delegate and recognize her.
I want to thank you very much, Chairman Mica, for the opportunity to testify. And I just want to say that under the Attorney General's policy, I think you're safe with that joint because the policy is not to enforce marijuana laws here in the District of Columbia, and I think even in the Capitol. Mr. Chairman, before I say a few words and summarize my testimony, I do have to say I think it's almost quaint to hear a jurisdiction of 650,000 American citizens referred to as a federal district. Not since the 1973 Home Rule Act, when Congress realized it was wrong to have a nation's capital where people could not govern themselves, that people referred to my district as a federal district. I, of course, recognize that the Congress kept unto itself ultimate power over the nation's capital while granting the citizens of this city the right to govern themselves and to make their own local laws in the same way as the members of the panel in their local jurisdictions have those laws made. Mr. Chairman, notwithstanding that ultimate power, I do note with great pleasure that this full committee on which I serve has, in fact, respected home rule. And this is the first time that I can remember that there has been a hearing in Congress on a purely local matter, notwithstanding the power of Congress over the District of Columbia. It simply has the good sense and fails to violate its own principles of local control most of the time by almost always not interceding into our local affairs as American citizens. As to the 20% of the District of Columbia that is federal land, Mr. Chairman, 6 or 7 states in the United States have most of their land to be federal land, and yet we do not claim, and this committee does not claim, that that presents any particular problem when it comes to the enforcement of local laws which may differ from federal laws. As to the location of a number of police forces here, Mr. Chairman, they will be enforcing federal law under the Attorney General's memorandum, which means that they will not interfere with local law in the District of Columbia as it has been passed with respect to marijuana decriminalization. Mr. Chairman, though I appreciate the opportunity to testify here this morning, I must say I come as much in protest as in the normal, the usual sense of testimony, because the subcommittee has singled out the District of Columbia on its marijuana decriminalization law as it has not singled out any of the other 18 jurisdictions who have similar laws. In fact, the subcommittee in 2 prior hearings has gone out of its way, although it was investigating exactly what it is investigating here, the conflict between federal and local law, to observe its often cited adherence to the 10th Amendment by not calling any local officials, even when it looked at Colorado in particular, which along with Washington, of course, has gone much further in decriminalization but has legalized marijuana. Still, no local official was called to Washington to be cross-examined, as it were, by the national legislature about what that local official was doing in its local jurisdiction. That, too, Mr. Chairman, is at the root of our Constitution. The ultimate authority of the District of Columbia came because Congress devolved that authority in 1973 in its landmark law, except for a few enumerated exceptions, and plainly marijuana decriminalization was not among them. Mr. Chairman, almost 40 years ago, the first state decriminalized marijuana. That was Alaska. Since then, red and blue states alike have decriminalized marijuana, from California to New York, from Mississippi to Nebraska. Nothing is similar about these states, except they have taken this particular step in keeping with what their local residents desired. Yet the District of Columbia is the only jurisdiction that has gotten a full-fledged hearing on its local decriminalization law. Nothing distinguishes the District of Columbia's decriminalization law from those 18 states, except the illegitimate power of the national government to do what would make the framers turn over in their graves, and that is to overturn the laws of locally elected officials in their own jurisdiction, in contravention of every American principle of local control of local affairs. This hearing stands out because it does not. It flies in the face of what my Republican colleagues often preach about devolving power back to local states and jurisdictions. This hearing does just the opposite, tries to snatch power by making the District of Columbia vindicate its local power and its local policy before the state legislature. I just want to go on the record to say we will defend this city's marijuana decriminalization bill against any and every attempt to block it or to change it. There will be, as a courtesy, a city police department official here today, but the mayor of the District of Columbia has informed me that he objects to this hearing, and he has refused to provide, as has the council, any official who has had anything to do or will have anything to do with advising or carrying out the marijuana decriminalization law in the District of Columbia. I'm also pleased to note that two majority members of this subcommittee, Representatives Justin Amash and Thomas Massey, carried out the principle of local control of local affairs by last week voting for the Blumenauer Amendment to prohibit local funds being used to implement the Veterans Health Administrative Directive that forbids a VA provider from completing forms seeking recommendations or options regarding a veteran's participation in a state marijuana program. Mr. Chairman, it took me 11 years to remove a marijuana, a medical marijuana amendment from the district's appropriation. Now, today, 21 states have medical marijuana. But, Mr. Chairman, the most important reason I am here today is to make it clear to the committee what really propelled the district to pass its own decriminalization law. Even though blacks and whites in the United States use marijuana at the same rate, a recent study showed that African Americans in our country are 4 times more likely, or almost 4 times more likely, to be arrested for mere possession. Mr. Chairman, it was interesting to note that in your own state of Florida, you are number 3 in the nation for marijuana possession arrests, and blacks in Florida are arrested for marijuana possession at a rate 4 times that of whites. But here, even in the progressive District of Columbia, where half of the population is black, we found an even worse record, that African Americans were 8 times more likely to be arrested for mere possession than whites in our city, and 91% of all marijuana arrests were of African Americans. These arrest rates are extremely troubling because in our city and across the country, they have ruined the lives of African Americans, who, especially young African American men, who start in life surrounded by a host of stereotypes, regardless of who they are or where they live, just because they are black. A marijuana possession arrest, particularly for these young men from low-income areas, will almost surely wipe out the opportunity to find a legitimate job. That, in turn, can lead to the underground economy, even selling drugs. Who is paying that price, Mr. Chairman? Is the black community itself.
I would like, if you could, to conclude. Now we're
I'm almost
6.5 minutes over what we allot. But I would also like to invite the gentlelady to come up and join the panel, and you'll have time here both to ask questions and submit additional information for the record.
Mr. Chairman, I do want to say, particularly given the concern, and I will simply leave the rest of my testimony, but the concern that a member has indicated about the use of marijuana itself, that is a very legitimate concern, and he can be assured that the District of Columbia, a big city which has experienced real drug problems, usually heroin and cocaine, very, very clear about the problem of people smoking marijuana. It has gone out of its way to make sure that decriminalization does not lead to more smoking of marijuana. In fact, ironically, I think decriminalization is going to start up for the first time an understanding of the risks that may be associated with smoking marijuana, whereas we haven't heard much about those until decriminalization took hold. But in a free society, of course, Mr. Chairman, we must respect the the liberty of Americans to use such substances rather than simply punishing use. The District of Columbia has a substance abuse prevention and treatment fund, which will be used, it will be engaged in preventative actions. Mr. Chairman, I'm asking that the city in any further action within this committee not be unfairly targeted, and that the members of this committee give the people who live in the District of Columbia the same respect for their local decisions as they would certainly demand for their own constituents and jurisdiction.
I thank the gentlelady, and we also welcome her to the panel and appreciate her testimony. We are going to go ahead and have the second panel seated, and if we could go ahead and do that, Ms. Norton, if you join us here, we'd appreciate it. I just say while they're doing that, let me put a unanimous consent request in the record, and this relates to marijuana, federal marijuana prosecutions. In August of 2013, the Department of Justice issued a memo stating that the Department of Justice will not enforce marijuana laws in states that have legalized it and maintain a robust regulatory scheme. However, the Department of Justice listed 8 priority areas for which they intend to focus marijuana-related prosecutions. One of those 8 areas, preventing marijuana possession or use on federal property, is one of those exceptions. Under these policies, it seems the federal district court would prosecute marijuana possession on federal land. This is in contrary to what we just heard, and that's one of the reasons. No one's here to negate the district law. We are looking at the implications and the enforcement regime, with 26 federal agencies responsible for enforcing different penalties. So with that, do we have all of our witnesses? If they'd step forward, we have Mr. Peter Newsham, is the Assistant Chief of Metropolitan Police. Welcome. We have Mr. Robert D. McLean, is the Acting Chief of the United States Park Service. We have Mr. David O'Neill as the Acting Assistant Attorney General of the Criminal Division at the U.S. Department of Justice. And we have our fourth witness is Ms. Seema and is Sandananan. Okay. Director of the American Civil Liberties Union of the National Capital. If you could remain standing, we do swear in all of our witnesses. If you would raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give before this subcommittee of Congress is the whole truth and nothing but the truth? Let the record reflect that all of the witnesses answered in the affirmative. Please be seated. We tried to get you to limit your testimony to 5 minutes. We'll be glad, through request of the chair, to add to the record additional information, data, or testimony that you would like made part of the record, and welcome you. Let's start out, and we'll start with Peter Newsham, who's the Assistant Chief of Metropolitan Police. Welcome, sir, and you're recognized. If you could turn that up, and I'm only a lowly congressman, so.
Good morning, Chairman Mica, other members of the committee, and members of the public. I am Peter Newsham, Assistant Chief of the District of Columbia Metropolitan Police Department. I'm pleased to be here today to discuss the District of Columbia's recent legislation to decriminalize small amounts of marijuana. The Marijuana Possession Decriminalization Amendment Act of 2014, D.C. Act 20-305, which is projected to become effective law in approximately mid-July, amends the District of Columbia's criminal code to decriminalize the possession of 1 ounce or less of marijuana. Instead of facing a misdemeanor charge punishable by up to 6 months in jail, up to a $1,000 fine, or both, Once the Act goes into effect, individuals will be subject to a $25 civil fine, and Metropolitan Police Department officers can seize any visible marijuana. The use of marijuana on public space will remain a criminal penalty punishable by up to 60 days in jail or a fine of up to $500. The Act defines public space as any street, alley, sidewalk, park, or parking area, a vehicle on any street, alley, park, or parking area, and any place to which the public is invited. Public attitudes about marijuana use have changed significantly in recent years, with many accepting it to be no more harmful or addictive than alcohol or tobacco. Decriminalizing marijuana may help reduce the number of people with arrest records for possession of small amounts of marijuana, which may enable them to more easily find gainful employment. The Act maintains criminal penalties for selling marijuana and public usage of marijuana, which is important to combat drug dealing and to ensure neighborhoods' quality of life. Even though the District of Columbia will decriminalize possession of small amounts of marijuana, we will continue to send the message, especially to our young people, of marijuana's danger and effects, just as we do with alcohol and tobacco, to discourage them from using it. Due to the District's unique status, some Federal law enforcement agencies, such as the U.S. Park Police, have concurrent jurisdiction in the District of Columbia and can enforce District or Federal law anywhere in the city. Although MPD officers will enforce the Act, the local Act, Federal law enforcement agencies are not bound by the Act so long as the possession or use of marijuana remains a Federal criminal offense. I thank you again for the opportunity to appear before you today. I'd be happy to answer any questions you have.
Thank you, and we'll hold questions to the end. Let's now hear from and recognize Robert McLean, and he's the Acting Chief of the United States Park Police. And you're recognized.
Thank you, sir. Chairman Mica and members of the committee, thank you for the invitation to appear before you today to discuss the Federal Government's response to the potential decriminalization of the District of Columbia's marijuana possession laws. My name is Robert McLean. I am the Acting Chief of the United States Park Police. I would like to submit the Department's full statement for the record and summarize those views here.
Without objection, the entire record will be, statement will be made part of the record.
The U.S. Park Police is one of the nation's oldest uniformed Federal law enforcement agencies. The Park Police has enjoyed a long history of partnership with the citizens of the District of Columbia and cooperation with the Metropolitan Police Department. The Park Police is responsible for safety and crime prevention in all parklands administered by the National Park Service. In the District of Columbia, the Park Police have primary jurisdiction over Federal parkland, which compromises approximately 22% of the District of Columbia, including the National Mall, East and West Potomac Parks, Rock Creek Park, Anacostia Park, McPherson Square, and many of the small triangle parks. The Park Police is a law enforcement unit of the National Park Service within the Department of the Interior, and our jurisdiction is usually set by congressional legislation. Officers of the U.S. Park Police are authorized under Federal law to make arrests without warrant for any offense against the United States committed in their presence within areas of the National Park System. Further, two additional acts of Congress provide that Park Police officers have the same powers and duties as the Metropolitan Police Department officers within the District of Columbia. Park Police enforcement is left to the sound discretion of the individual officer on the ground, depending on the circumstances. If an individual is arrested for simple possession of marijuana by one of our officers within the district, the arrestee can be currently charged under D.C. Code. Under existing D.C. law, simple possession of marijuana is a misdemeanor with a penalty of incarceration of up to 6 months and a fine of not more than $1,000. If the violation occurs on Federal parkland, the arrestee can be charged under the National Park Service regulation at Title 36 CFR, resulting in a misdemeanor with a possible penalty of incarceration of up to 6 months and a fine of not more than $5,000. Finally, marijuana is a Schedule I controlled substance under Title 21 United States Code, the possession of which is a misdemeanor, and in the event of a conviction, the sentence is determined by the court. Between 2010 and 2012, approximately 55% of the Park Police arrests for marijuana charges in the Washington metropolitan area occurred on Federal parkland within the District of Columbia. The majority of these arrests were for simple possession, with a few arrests for possession with intent to distribute. We understand that the District of Columbia's Marijuana Possession Decriminalization Amendment Act of 2014 would only amend district law and would not alter the National Park Service regulation or federal law on marijuana. We also understand that the D.C. Act would still make it a misdemeanor to smoke marijuana in a public space or park. If the D.C. Act becomes law, then we will work closely with the United States Attorney's Office for the District of Columbia to determine our future enforcement options, especially if the person is on federal parkland. Mr. Chairman, this concludes my statement. I will be pleased to respond to any questions you may have.
Thank you, Mr. McLean, and we appreciate your testimony. We'll now turn to David O'Neill, the Acting Assistant Attorney General, Criminal Division at the United States Department of Justice. Welcome, sir, and you are recognized.
Thank you, Chairman Mica and distinguished members of the subcommittee. I appreciate your invitation to testify on behalf of the U.S. Department of Justice. My testimony today will focus on our marijuana enforcement program nationwide and the guidance the Department has issued to all United States attorneys regarding our program. As you know, the Controlled Substances Act of 1970 makes it a federal crime to possess, grow, or distribute marijuana. Financial transactions involving proceeds generated by marijuana-related conduct can also form the basis for federal prosecution under money laundering statutes, the Unlicensed Money Remitter Statute, and the Bank Secrecy Act. Starting with California in 1996, several states have authorized the cultivation, distribution, possession, and use of marijuana for medical purposes under state law. In 2012, voters in Colorado and Washington approved initiatives legalizing marijuana use under state law and establishing state regulatory systems for marijuana use. In 2010, the Council of the District of Columbia authorized the use of marijuana for medical purposes, and following congressional review of that legislation, it became law in the District of Columbia. The Council has now enacted broader decriminalization legislation, which is currently under congressional review. The administration will treat D.C. in the same manner as every other jurisdiction with respect to the enforcement of federal marijuana laws. In the District of Columbia, the U.S. Attorney's Office will also continue to enforce drug offenses under the D.C. Code. For decades and across administrations, federal law enforcement has targeted sophisticated drug traffickers and organizations, while state and local authorities generally have focused their enforcement efforts under their state laws on more localized drug activity. Since medical marijuana laws and decriminalization laws have been enacted, the Department of Justice has continued to work with its state and local partners to target dangerous drug trafficking organizations. At this point, more than ever, we will maintain strong partnerships and coordination among federal and state and local law enforcement. On August 29, 2013, the Department issued a guidance memorandum to all United States attorneys, directing our prosecutors to continue to fully investigate and prosecute marijuana cases that implicate any one of 8 federal enforcement priorities. This memorandum applies to all of our federal prosecutors, and it guides the exercise of prosecutorial discretion against individuals and organizations that violate any of our stated federal interests, no matter where they live or what the laws in their state permit. Using our prosecutorial discretion, U.S. Attorneys' offices have historically devoted resources to cases involving these 8 federal enforcement priorities and will continue to do so in the future. For example, we have targeted enforcement actions against marijuana businesses and residential grow sites near schools. We also actively investigate and prosecute cases involving international smuggling and interstate shipment of marijuana, marijuana grows where firearms and violence are involved, marijuana grows on public lands, and cases with potential organized crime involvement in marijuana businesses. In addition, in February 2014, the Department issued guidance to all federal prosecutors regarding marijuana-related financial crimes. That guidance seeks to mitigate the public safety concerns created by high-volume, cash-based businesses without access to banking and the financial system, while at the same time ensuring that criminal organizations, gangs, and drug cartels do not have access to the financial system to launder criminal proceeds. The guidance states clearly that the provisions of the money laundering statute, the unlicensed money remitter statute, and the Bank Secrecy Act remain in effect with respect to marijuana-related conduct. The guidance advises Federal prosecutors to assess marijuana financial crimes under the 8 Federal enforcement priorities laid out in the August 29th memorandum. The Department expects financial institutions to continue to apply appropriate risk-based anti-money laundering policies, procedures, and controls sufficient to address the risks posed by these customers. This includes conducting customer due diligence consistent with any guidance issued by FinCEN. The Department of Justice is committed to enforcing the Controlled Substances Act in all states and the District of Columbia, and we're grateful for the dedicated work of our Drug Enforcement Administration and Federal Bureau of Investigation agents, our Federal prosecutors, and our state and local partners in protecting our communities from the dangers of illegal drug trafficking. Our goal is to ensure that we are effectively focused on the 8 Federal enforcement priorities outlined in the August 2013 and February 2014 guidance from the Department. Ultimately, the achievement of that goal requires cooperation among law enforcement agencies at every level. I look forward to taking your questions.
Thank you, and appreciate your testimony. We'll go now to Ms. Sandanandan, and she is the Program Director at the American Civil Liberties Union here in the nation's capital. Welcome, ma'am, and you're recognized.
Chairman Mica, Ranking Member Connolly, and distinguished members of the subcommittee, thank you for this opportunity to address D.C.'s overwhelmingly popular decision to decriminalize small amounts of marijuana. My name is Seema Sandanandan, and I'm the Program Director of the ACLU of the nation's capital. We work to protect civil liberties and civil rights in Washington, D.C. through public education, legislative advocacy, and litigation. In 2013, the ACLU published a nationwide study of the widespread racial disparities in marijuana arrests from 2001 to 2010. The report documented arrest rates for marijuana possession by race for all 50 states and the District of Columbia. The ACLU of the nation's capital soon thereafter issued a shadow report entitled Behind the D.C. Numbers, The War on Marijuana in Black and White, focusing on racial disparities in marijuana arrests here in the district. While the ACLU's nationwide study found Black people to be 3.7 times more likely to be arrested for marijuana possession than whites, in the District of Columbia, Black people were a staggering 8 times more likely, despite roughly equal usage rates among Black and white populations. These reports catalyzed several months of high-profile public debate about police enforcement practices here in the district. There emerged a public consensus that the aggressive enforcement of marijuana possession did not make our communities any safer. In the face of increasing public pressure, in March 2014, members of the D.C. Council passed by a margin of 10-1 the Marijuana Decriminalization Amendment Act of 2014. Prior to the passage of the act, adult possession of marijuana was a misdemeanor, punishable by up to 6 months in jail or up to a $1,000 fine. The act to decriminalize marijuana makes marijuana possession of 1 ounce or less a civil offense under D.C. law, subject to a $25 fine. In passing this act, the district joined 11 other states which had already instituted similar legislation. In 2010, as you can see the graph here, Black and white populations in the district were nearly equal, yet nearly 91% of all arrests for marijuana-related offenses were of Black people. In 2010 alone, 5,393 arrests for marijuana-related offenses. Approximately 3/4 of those arrests were for marijuana possession. In 2010, law enforcement officers in the District of Columbia were making approximately 15 marijuana arrests per day. Usage rates do not explain this glaring racial disparity in the enforcement of the district's marijuana laws, particularly where time and time again studies have shown that Black and white populations use marijuana at remarkably similar rates. This is a 2010 nationwide survey by the National Household Survey on Drug Abuse and Health. We have the 2001 and 2010 survey here, which showed that based on self-reported usage rates between Black and white populations, you have near equal rates. In addition, studies have consistently indicated that drug markets, like American society in general, reflect our nation's racial and socioeconomic boundaries. For example, university students tend to sell to one another. Here we have a map of all the marijuana arrests in the District of Columbia. The yellow points indicate the arrests of Black individuals, and the blue points indicate arrests of white people. This map demonstrates that the vast majority of the arrests in the District of Columbia took place east of 16th Street. And for anyone who lives here in the district, you know that these are the neighborhoods where the overwhelming majority of Black residents live, and far from the 4 major universities that lie west of 16th Street. When faced with the question of what to do about these disparities, the Council considered several key factors in support of marijuana reform. The cost of marijuana enforcement was a huge factor. The district spends more per capita on marijuana enforcement than any of the 50 states. By a conservative estimate, D.C. in 2010 spent approximately $26 million on marijuana enforcement. Second, focusing valuable police time and resources on marijuana enforcement reduced police ability to respond to and solve more serious crime. And finally, saddling thousands of primarily Black men in the district with convictions for marijuana possession year after year, with negative consequences for employment, education, and housing, did not serve the interests of public safety and had a corrosive effect on the relationship between police and the community. Based on these factors, the policy choice was clear. The Council overwhelmingly decided to remove criminal penalties under D.C. law for marijuana possession. Before I close, I'll briefly address the issue of federal versus local marijuana enforcement. According to our data, which we obtained through a FOIA request from the Metropolitan Police Department, 93% of all marijuana arrests in 2010 were made by the Metropolitan Police Department. Less than 3% of all the arrests in the District of Columbia for marijuana-related offenses were made on federal land. According to our estimates, approximately 99% of all arrests were made under the D.C. Code. Accordingly, we do not predict a significant tension between federal and local marijuana enforcement in the wake of reform. We urge this committee to respect this local and widely supported measure to address racial disparities in marijuana enforcement in the District of Columbia. Thank you.
Excuse us. Well, thank each of our witnesses for their testimony and participation. Also, failed to say at the opening, thank you again. We've had to change the scheduling of this hearing at least twice, and yesterday, in deference to our departed member, the late Mr. Jim Oberstar, Ms. Thornton and I and many other members were at his funeral. So that's the reason, and I appreciate so much your complying. Let me start with some quick questions. Okay. I cited, in fact, Mr. O'Neill, that there are 26 federal law enforcement agencies. You issued and you cited the August 29th, 2013 memo that the U.S. attorneys wouldn't be going after some of the laws in these states. At least you wouldn't be going after, as far as federal prosecution, some of the laws. You did cite 8 exceptions, and the 8th one I have here, which I put in the record, was preventing marijuana possession or use on federal property. Is that correct? Is that part of what was issued?
Chairman Mica, I guess I would characterize the memo slightly differently. I think it was not an indication that we would not prosecute federal marijuana laws except where those exceptions or where those areas are indicated. I think what I would say is that that memo indicated that those are the areas where we are going to focus our priorities. So we have instructed Federal prosecutors to focus on those areas. And,
right.
And you are
so, and one would be preventing marijuana possession or use on Federal property.
That's correct. I think
that is correct.
That is one of our
in
priorities.
conflict to some comments that have been made about what the Department of Justice has said and what they would do. We also have also looked, and we called in your U.S. Attorney from Colorado, because that is one of 2 states that have, now we have 20 states that have gone in for the medical marijuana, but we have the penalties basically eliminated for possession, I believe, in Colorado is the other one, Washington. So we're not picking on the district, we're looking at the implications from Federal prosecution. Mr. McClain, and you cited, too, that you will be enforcing Federal law on Federal property. Is that correct?
That is correct, sir.
As far as possession, which are you going to enforce? The district law or Federal law on Federal property? If I've got this little old joint here and just possession, what are you going to do? And I'm on Federal property, Park Service, and you told me all the area that you cover. What law are you going to enforce if this goes into effect in a few more weeks here?
The current law over National Park Service land in the District of Columbia is Title 36, Code of Federal Regulations.
So you will enforce the Federal law in conflict to the, in deference to what the district has passed, right?
That's correct. We also have available to us the authority
and
under
you would,
21.
You would prosecute that. I guess the prosecutorial agency would either be, well, the district has a different law, so it would end up in the Federal courts. Is that right?
The U.S. Attorney's Office for the District of Columbia has authority in the district for prosecuting cases or offenses under the D.C. Code. And so to the extent it was an arrest was made under the D.C. Code, that would be prosecuted in Superior Court. To the extent a case was brought to us in violation of Federal law, then yes, that would be prosecuted in Federal District Court, although... And
McClain just testified 55% of your, give us exactly, I don't want to change the words of, but the marijuana possession were 55% of offenses, or what was that number?
Of the specific year, 55% of the arrests made for marijuana possession by the United States Park Police occurred on Federal parkland.
On Federal parkland.
Correct.
So we could have increased number given the disparity. I'm not here to negate the district law. We're here to review what the district passed, and there have been precedents for that. And I'm not here to just review its implications in the district. We have at least 2 states that, and we've had one hearing on one of the states and the U.S. Attorney to see how this would be administered and executed under the law. So again, and I've already put this in the record, we would have Federal prosecution. It would be at a higher level. We still have the issue, and I think you brought it up, Chief Newsom, of this being a Schedule I Federal narcotic, too, even though the district has, again, reduced the penalty, and you have jurisdiction on all of the non-Federal land, so you would prosecute it under the new statute. Is that correct?
Yes, that's correct.
Okay. Well, again, it isn't a purely local matter, particularly given the relationship between the District of Columbia and, again, its unique status in the scheme of political and enforcement jurisdictions. There's no question there's disparity in the prosecution when it comes to blacks. Our prisons probably, I don't know the current number, but probably half the population of the prisons, state, local jails are filled with African Americans. The number of people in jail for various penalties, there's probably a larger population of African Americans in jail and prosecuted for a whole host of crimes. And that's wrong. In many cases, it's wrong that they find themselves in that situation in the beginning. But I'm not certain that, again, changing the penalty in the District of Columbia is going to benefit that population that much. Unfortunately, marijuana, Ms. Sandin, becomes a gateway narcotic, and that's what we had testify the Office of National Drug Control Policy Director under the Deputy Director under the President of the United States, who brought up some of this topic by comparing the use of marijuana equivalent to alcohol. So again, it's not a question, but a response to some of your comments. There are inequities that need to be resolved. I appreciate each of you coming. We're trying to sort through this, its implications. I don't know what the administration will do on the categorization. Do you have any recommendation, Mr. O'Neill? Probably not.
In terms of scheduling of
Yes.
marijuana?
Yeah.
No. There's a process for considering that, which would begin with a petition to the DEA, which then would be referred to the Department of Health and Human Services for a study and a recommendation.
Yes.
So
and we plan to bring in people from the scientific area to see what's out there and, again, review that whole process. And right now, with the laws changing, as you testified to, and we all see across the land, we need to see where we're going with this. I thank both of you. You're both law enforcement officers for the job you're doing, and I hope you see the problems that we're trying to sort through as a committee. Ms. Norton. I'm going to try to stick to the 5, Ms. Norton, because we do have 5 votes scheduled soon.
Thank you, Mr. Chairman. Just to clarify, Mr. Chairman, on parkland and federal property, nothing I said was meant, and I heard nothing that said that federal law would be any different on federal property. Federal Park Service property, federal buildings. I joked about how you wouldn't be arrested here.
Even up here, Mr.
Yeah, I just, since it's federal property, you may be in some jeopardy up here, Mr. Chairman. But what I was pointing out is that parkland and federal property is to be treated the same way here as in other parts of the United States. Isn't that true, Mr. McLean and Mr. O'Neill?
that's correct.
Yes, ma'am.
I mentioned when the chairman pointed out 20% of the land was federal parkland or federal property, that there were any number of states. Staff has given me some of them, Nevada, Utah, Alaska, where the entire state virtually is owned by the federal government. How do you, does that create any particular difficulty with respect to for example, in Alaska, where they have decriminalized marijuana? Has the fact that so much of Alaska is federal land create any particular difficulty to forcing federal law on federal land? Mr. O'Neill.
I'm not aware of any particular difficulty arising from the high percentage of federal land in a state like Alaska. You know, as you pointed out, we are going to approach marijuana enforcement in the District of Columbia just as we do in states like Colorado, Washington, other jurisdictions that have chosen to amend their laws in this way.
I just want to note for the record that the federal government owns 81% of the land in Nevada, 66% in Utah, and 61% in Alaska. Mr. Newsom, does the district's marijuana bill change D.C. law regarding the sale and distribution of marijuana or intent to distribute marijuana.
That would still be an arrestable offense.
What about notification of parents and guardians if you find marijuana in the hands of a youth?
The youth would be issued, for less than an ounce, would be issued a notice of violation. And then again, with regards to distribution, it would be an arrestable offense, and parents would be notified.
Ms. Sandinen, you noted that where there are a great many young people, because this is a college town, east of 16th Street, there are almost no arrests. West of 16th Street, there are almost no arrests, but there are. In that map, they showed high numbers in many areas where African Americans live. Why do you think? How come there are so many arrests for mere possession there? How do they come about?
Well, the study that we did was a descriptive study, so we looked purely at sort of the arrest data, but based on anecdotal evidence, there's a number of different reasons that have to do with the way in which marijuana enforcement is prioritized by various agencies. And I think that you can look, even with the number of various law enforcement agencies here in the district, you see more than 93% of the arrests are happening through the Metropolitan Police Department. And
are these youngsters or people, whatever their age, picked up, do you think, because of the smell or odor of marijuana?
According to reports from young people in the district, it was under the alleged smell of marijuana that they were being singled out for stops and searches. But what we found in our data is that the majority of people who were actually arrested were not young people at all. In fact, juveniles made up less than 4% of actual arrests for any type of marijuana.
I don't mean juveniles. I don't mean juveniles, Ms. Sandinen. I mean young people.
Yeah, absolutely. So the pretext of odor was definitely being used to according to anecdotal evidence, to stop and initiate contact.
What's the reason for the low fine?
The reason for the low fine is because the majority of the areas of the district where people were being arrested are areas with high rates of low-income individuals. And the implication for a $25 fine is very different for a person who is living at or below the poverty line than, say, for example, a person who is middle class or upper middle class. And so the $25 fine is more likely, based on the arrest patterns we see now, to be levied against someone of low income. And so we wanted a fine that was a deterrent for engaging in possession but it was also manageable and realistic and didn't saddle someone with an additional burden which would be unrealistic for them to actually pay.
Thank you, and thank you, Mr. Chairman.
Thank the gentlelady. Mr. Massey.
Thank you, Mr. Chairman. I find the racial disparity aspect of the enforcement and prosecution of these laws very disturbing. But it does strike me that the answer might not be just to ignore the law when we find a problem like this. Ms. Sadanandan, did you find racial disparity in distribution crimes as well as possession? Or have you looked at that distribution growth?
Our report didn't look specifically at distribution, but what I can say is this. Based on just a survey, a general survey of the number of, for example, distribution crimes in an area like District 7 of the Metropolitan Police Department, which is, a largely African-American section of the district versus District 2. We did find that in District 7, for example, there were 276 arrests for distribution in a given year. In District 2, there were approximately between 20 and 30 arrests. Yet the yield for marijuana was much, much higher in District 2 than in District 7. So,
what I'm trying to find out is, do you anticipate, so there's still going to be arrests for intent to distribute. That really hasn't changed in the D.C. law. Do you anticipate a racial disparity continuing in enforcement of this law?
We
with the other law?
anticipate that there will be less arrests, but yes, the disparity will continue. It just won't continue on the scale that we're seeing now.
Mr. Newsham, two of the witnesses have testified that there's a racial disparity in the application of this law. In your opinion, why are blacks arrested at a higher rate than whites for marijuana, and what are you doing about that? I mean, the law, it's not up to you to set the laws, but the enforcement of it is. What can you do and what have you done to address that disparity?
Yeah, I don't know if I heard folks say that it was the enforcement of the law that was causing the disparity. I think that when you take a look at something like this, if you're looking at race for a particular crime where arrests are being made, I think other factors have to be considered before you draw any conclusions as to what the cause is. One of the things that we looked at as a department, because we're very sensitive to the allegation that laws are being biasly enforced.
Understood.
Obviously.
That's why I wanted to give you a chance to answer that.
Yeah, so we looked at calls for service, and if you talk about that study where they talked about two separate areas of the city, we call them patrol service areas. One was in the 2nd District and one was in the 7th District. And this is just as one of the things that we saw is that in PSA 204, which is in the 2nd District, which is a predominantly white neighborhood, there were 12 drug calls for service, and we had 12 marijuana arrests. And then in PSA, I believe it was 602, which is in Anacostia, which is a predominantly black neighborhood, we had 518 calls for service, and we had 249 marijuana arrests. So the calls for service are drawing the police to these areas, and the calls for service are the community. It's the community that calls the police to come and take enforcement action. So I guess why I say all that to say is I don't want anybody here to leave with the impression that the Metropolitan Police Department or any law enforcement agency in the city it's law enforcement tactics that are causing that. I think we need to take a closer look at the causes.
Thank you. Mr. O'Neill, who determines the prosecution priorities at the Department of Justice?
Ultimately, the Attorney General and the Deputy Attorney General, and then in each of the districts,
So it's the Attorney General, Eric Holder, who determines ultimately the priorities?
Yes, the Attorney General, though, as I said, in any particular district, the U.S. Attorney also has discretion about how to enforce the law based on the particular circumstances of that area.
So have you had any directive? I mean, I heard you say earlier that you would enforce the laws in D.C. on federal property the same way you would in Colorado or Washington. But are you going to be any more or less diligent about prosecuting arrests on federal property in states that have more lenient marijuana laws than in other states?
No, we're going to approach it. I mean, that was really the point of the August 2013 guidance, is that this is the enforcement priorities of the department across the entire country, regardless what the state law is.
So there'd be no deference to state law on federal property in those states?
I think, our enforcement of marijuana laws on federal property will be the same regardless of what the applicable state law is.
Thank the gentleman.
Thank you.
Need to recognize Mr. Jordan.
I thank the Chairman. Mr. O'Neill, tomorrow, May 10th, will mark 1 year since Lois Lerner went to a bar association here in town and disclosed that the Internal Revenue Service was targeting conservative groups. 4 days later, the Attorney General announced, after saying that this activity was outrageous and unacceptable, announced that there would be a criminal investigation. A month into that investigation, we had then FBI Director Mueller in front of the committee. He was asked 3 questions. Who's the lead agent on the investigation? How many agents have you assigned? And have you interviewed any of the victims' groups? Mr. Mueller's responses to those questions were, I don't know, I don't know, I don't know. But what he also said was, I'll get back with you, implying that we should, in fact, know some of that basic information. So I would like to know a couple things. We know Ms. Bosserman is involved. She's interviewed many of the witnesses, because those same witnesses we've interviewed, and they've told us she's been interviewing them. She's in the Civil Rights Division. But the Attorney General has told us the Public Integrity Section is involved too. Is that accurate?
Both the Civil Rights Division and the Criminal Division of the Department of Justice are involved, as are career agents at the Federal Bureau of Investigation and the Treasury Inspector General.
Can you tell me some of the basic information about the questions I asked Mr. Mueller almost a year ago? Who, in fact, is the lead agent on this investigation?
I'm sure that we can provide that information to you.
Well, we've asked you 7 times. We've sent 7 different inquiries to the Department of Justice, and each time they can't tell us anything. They just say it's an ongoing investigation. Now, Mr. Mueller didn't say that. He told us he'd get back with us and give us the information. So now, Mr. O'Neill, you're acting assistant AG for the Criminal Division, so you manage the Public Integrity Section?
I oversee the Public Integrity Section.
Are you involved in the investigation of targeting of conservative groups by the Internal Revenue Service?
I would disagree with the characterization. I don't.
Are you involved?
Am I involved in the investigation? I oversee the Public Integrity Section, so yes.
Do you know an attorney named J.P. Cooney?
I'm not familiar with that name.
Mr. Cooney is in the Public Integrity Section. We understand he's involved in the investigation. You know if he's the lead agent?
As I said, I'm not familiar with the name. So
can you tell me who's leading the investigation? There's got to be someone in charge. Who's the point person on the investigation and the targeting of the Internal Revenue Service of conservative groups?
Congressman, obviously this is far afield of the subject of the hearing that we're.
But you oversee the Public Integrity Section, the Criminal Division that's involved. I just want to know who. You don't know who. This is one of the biggest cases you got. You don't know who's leading the investigation?
There are numerous career federal prosecutors that are on that investigation.
Can you tell me how many? We've been trying to get this answer now for 11 months.
How many prosecutors in total? I can't tell you that answer sitting here today.
Is this an important case for the Justice Department, finding out how people's First Amendment rights were violated and they were targeted by the Internal Revenue Service? Is this an important case?
I mean, again, I would disagree with the characterization of the investigation, but yes, this is an important case to the Department.
And you don't know how many agents are involved? You don't even know how many agents are involved from your division?
Well, the agents would be involved from the Federal Bureau of Investigation or
How many attorneys from your division?
I can't give you a precise number. I don't want to give you a precise number and have that be incorrect.
Earlier this week, in a bipartisan majority, 26 Democrats joined Republicans, joined every single Republican. 26 Democrats said that we should have a special counsel take over this investigation. So 26 Democrats joined with us, saying things like this, quote, "The statements and actions of the IRS and the Department of Justice and the Obama administration in connection with the matter have served to undermine the Department of Justice investigation." End quote. That was part of the resolution. 26 Democrats agreed with that quote. Do you think we need a special counsel to take over this investigation? That no one seems to know how many agents are involved, how many attorneys are involved. No one can tell me who's leading it. FBI Director Mueller couldn't tell me. You can't tell me. Even the number involved from your division. Do you think we need a special counsel? Do you agree with the 26 Democrats who agreed with us with that resolution?
You know, I think that the Attorney General, the Deputy Attorney General, and others in the Department have answered that question. I think the answer is that no, a special counsel is not warranted.
So you're not going to recommend a special counsel?
No.
You don't think the Attorney General is going to even consider that question at all? Even though 26 Democrats, a bipartisan majority in the House of Representatives, said, what's going on at the Justice Department, it's not the kind of investigation we want. We think it's time for a special prosecutor.
Again, I think that, you know, that suggestion has been made, and I think that
it wasn't a suggestion. It wasn't a suggestion. It was a vote of the United States House of Representatives with 26 Democrats joining Republicans saying what's going on at the Justice Department is not a real investigation. When the person leading the investigation, Barbara Bosserman, gave $6,750 to the President's campaign and the Democrat National Committee, even 26 Democrats agree something else has to happen. Someone else should be in charge.
Again, Congressman, I think that the prosecution here is being led and managed by career prosecutors in the Criminal Division, the Civil Rights Division, with assistance from career agents in the FBI and the Treasury Inspector General. And I think the Attorney General and the Department have confidence.
Mr. Chairman, I hope the Attorney General will listen to what 26 fellow Democrats in the United States House of Representatives had to say earlier this week when they voted and said we need a special counsel.
The gentleman, here's what's going to happen. We have less than a minute now remaining in a vote, so I'm going to recess the hearing until 12:15. We will try to conclude it by about 12:30, 12:35. We have at least a few more questions to be asked. So the subcommittee will stand in recess to 12:15.